moving away a little bit from the courts and speaking about the tribunals on the same subject, how do tribunals manage conflicts between the substantive law and the contracts and the rule of private law?
So tribunals, as we know, arbitral tribunals, as we know, have quite broad substantive decision-making authority. With respect to procedural matters and the validity of the arbitration agreement, tribunals are bound by, of course, the parties' agreement and subject to at least a degree of national court scrutiny. Did they correctly or incorrectly decide the question whether there is a valid arbitration agreement? With respect to substantive disputes, does this contract impose an obligation to deliver the goods at a particular time in a particular condition or not? Tribunals have quite broad authority. Their mandate, of course, is to give effect to the parties' agreement, applying the law that the parties have chosen to apply to that agreement. But there's virtually no national court review of the substance, the merits of their decision. Tribunals, in my view, properly give enormous effect to the terms of the parties' agreement. They seek to effectuate the parties' commercial bargain. They will, of course, look at that agreement, that bargain, in the light of the applicable law. They will attempt to apply to the best of their ability private international law rules to select the substantive national law that governs the contract or the non-contractual claims, and they will give effect to that law. I think inevitably there is a bit of a tilt towards giving effect to the parties' agreement if there should be some conflict between that and a putatively applicable national law. In part, I think that is because of the nature of arbitration. It arises out of commercial dealings, and I think there's therefore quite substantial respect for the parties' commercial bargain, and perhaps I wouldn't say less respect, but that the parties' commercial agreement is given respect, even in the context of national legislation or judicial decisions that might be less enthusiastic about giving effect to the parties' agreement. I think arbitration really does seek to effectuate the parties' bargain.